Andrew Weissmann, let me bring you in. I want to show you some of what Fani Willis had to say about not treating different targets of an investigation differently. Let me play this.
If you are a member of a gang and you're committing a crime in my community, I am going to make sure that you are held responsible to the full extent of the law. People also seem to think that in society that there are certain people that are immune from prosecution. If you are a celebrity, if you are a high-ranking public official, I guess that there is something strange with me. Lady Justice is actually blind. This is the reality.
A very welcome thing to hear when you take into consideration the pace of the criminal probes into Donald Trump. I spoke to a couple of members of the Select Committee. I think it was Congressman Adam Schiff on Friday. And I said, look, in the time that Republicans supported an independent commission to investigate the insurrection, gathered votes for it, then decided against that and killed it. And the Speaker assembled a select committee. The select committee hired investigative staff. They conducted an interview, interviewed 1,000 people, put on public hearings, and dismantled nothing from the federal criminal justice system on Trump's role in inciting a deadly insurrection on January 6th. Fani Willis, though, also in that amount of time has concluded her criminal probe. What are you looking for in terms of tea leaves?
Well, first, I think it's so commendable, her statement about the rule of law and treating everyone the same, because let's get real. Rich people, white people, public celebrities, politicians are treated more favorably by and large in the criminal justice system, and that is deplorable. So it's really wonderful to hear her say we're going to treat people the same, not better or worse. That's what it means to have the rule of law. And in terms of what I expect to see, obviously this is guesswork, but to me, this feels like an incoming heat-seeking missile. We're in this unusual position where there's sort of a two-step grand jury process, which is different than at the federal system. So there's a grand jury that just writes a report and hears evidence, and there's another grand jury that can actually bring charges. It is inconceivable to me that the first grand jury, having heard all of the evidence that you outlined, Nicole, that they're not going to say that there is probable cause, which is a relatively low standard, to bring charges against the former president. And with that, I think it makes it very hard for Fani Willis to then not bring those charges and not have a second grand jury actually present those charges. So to me, this feels not even like the calm before the storm. I mean, this to me is we are about to see the final step with Georgia charges against the former president. And the final point I'll make is, we focus so much at the federal level, but these charges are the ones that can stick, because regardless of whether a Republican wins the White House eventually, these charges are not subject to a federal presidential pardon. So, if you are Donald Trump right now, you have to be really concerned about what is going to happen in Georgia. And you can be sure he's going to start attacking Fani Willis like crazy and the system. But these are the charges that I think he should probably be most worried about.
Andrew Weissmann, I was girding for a technical legal term, and then you dropped heat-seeking missile, and I think we were mind-meld. I have a follow-up question for you, though. There's some brand new reporting out today that adds to our picture that Blaine has really painted for us with her great interviews and coverage of Fani Willis. But let me read this to you out of today's Washington Post. Using Georgia's expansive anti-racketeering law, a statute traditionally used against drug dealers, gang leaders, and mafia figures, she and her colleagues won guilty pleas from 21 educators and the convictions of 11 others in 2015 for accepting bonuses and other rewards while students suffered losing access to remedial education. Now, Willis is considering using the racketeering statute in another sprawling, politically treacherous investigation. The question this time is whether a former president, Donald Trump, conspired with his allies to break the law and attempt to overturn the 2020 election. Observers say the threat to Trump is real and immediate, and that the Fulton investigation could make him the first sitting or former president to be indicted on criminal charges. Willis has said she is considering subpoenaing Trump, has notified at least 18 others they are targets in good faith indictment. The allegations are very serious. If indicted and convicted, people are facing prison sentences. What is your assessment of that sort of legal strategy of using Georgia's expansive anti-racketeering laws?
That's such a good question. So this really goes to a strategy call that, Barb and maybe Claire have had to make and I have had to make. I have to say that I'm generally of the view that you sort of lead with your strongest case and you keep it narrow and focused if you've got a strong case. Sometimes when you go broad, you create a bigger target for the defense to pick apart. So you want to just go with your absolute strongest case and just try it and keep it clean and quick and get in and get out. So that's sort of my sort of predilection and the way I sort of think about things. It is, however, very hard to second guess that when you're not inside and being able to truly assess the strength of the case. But in general, I wouldn't be a fan of going big unless you really have the evidence and you're not creating a target for the defense.
So, Barb, I want your legal analysis as well. I also want to add another layer to this. I mean, Blaine made the wise point that we don't know what we don't know in terms of who testified before Fani Willis's special grand jury that was assembled for this. But what we do know is that in terms of the investigations into Trump's role in overturning his defeat in 2020, she did have access to, again, we don't know what they said, but she did have access to more people than seemed to have cooperated with the January 6th Select Committee. So your thoughts on the witnesses that we know about and what appears to be some reporting about what could be her legal strategy?
Yeah, so this idea about racketeering, I think, is a very interesting one. I think you can err on the side of going too big, and you can also err on the side of going too small. I've used racketeering statutes when you've had a criminal enterprise that's involved in a number of different types of schemes. For example, we had a public corruption case where the schemes were extortion and bribery and fraud and tax charges. And racketeering allows you to bring that whole case under one umbrella so that a jury can get the flavor for all of the criminal activity. But it could be an overkill to do that when the criminal conduct is really very focused on one crime, as it seems to be here, which is the crime of trying to defraud an election. And so in that case, I would think that you would want to be more narrowly focused on that. But you can go too far. I've seen cases where people go for the one and only single clean charge that they can find, and they ignore a lot of criminal activity. And then a jury is left not to know about all of that other criminal activity and to believe that the sole crime was this one little thing, like the one phone call. And so I think it's very important that Fani Willis here get the Goldilocks case, the one that's neither too big nor too small, one that encompasses all of the crimes here without trying to stretch it beyond its normal bounds. And so I would think that anybody involved in a conspiracy to undermine the outcome of this election would be fair game for a crime, but I would focus very much on the events occurring leading up to the November 2020 election and anything up to that phone call in early January of 2021.
Barb, let me drill down on one witness that we know was there, that spent at least a day there, and that's Cassidy Hutchinson. We know that she has firsthand knowledge of Trump's knowledge that he was defeated. It's a little snippet of testimony that has haunted me since I first heard it, and I read it again in her transcript. She and Mark Meadows are walking down the colonnade, as picturesque of a setting and on that 18-acre complex as any, and Trump lumbers toward them and says, no one can know we lost, which is both delusional and it would appear sort of smoking gun evidence that even he was aware that he had lost the 2020 election. And then the call comes to find 11,780 votes. How is Cassidy Hutchinson likely to have been used by this criminal probe as a witness against Mark Meadows and Donald Trump?
Yeah, I think that exchange, Nicole, is critically important. It isn't just, a made-for-Hollywood moment. It's a made-for-the-courtroom moment. There has been some criticism of the testimony of Cassidy Hutchinson when it relates to things like what happened in the presidential limousine on January 6th, because her knowledge was hearsay. This is not. This is firsthand observation. She is a percipient witness to this exchange, and she can testify about it. I would add on to that the other evidence that Donald Trump knew he had lost before making that call, what William Barr said to him, what Chris Krebs said to him, what the Justice Department said to him. He absolutely knew by the time he made that call that the election was lost and it was a legitimate election. And so that is essential to proving a criminal intent to defraud. And so I think Cassidy Hutchinson could be a very important witness in this case in Georgia.